Hello, this is Devin Easterlin from SJA Property Management, and here is another edition of Landlord's Corner. Today we're going to talk a little bit about pets and pet policy when it comes to rentals. It's a question we get asked quite often from prospective landlords. Can I limit pets in my property? And the quick answer to that is yes, you can. Pets aren't a protected class, and therefore you can limit whether you're going to have them at all. You can also limit whether you're going to allow certain breeds but not others. Say you'd want to prohibit dangerous breeds. You can also charge an additional security deposit or additional pet deposit. Some cases landlords charge an additional fee, oftentimes called pet rent. So that is all available to you. One thing that you want to think about when you make that decision is there's, according to NARPM, the amount of tenants with pets looking for properties about 70 to 75%. So you can imagine if you limit saying no pets in properties, you now have a much smaller pool from which to draw from to fill your vacancy, which could extend your time on market. Just something to think about. Also, you want to check with your HOA. If you live in a condo or if your property's in a condo, then there may be a limit on weight. Oftentimes the pets can't be bigger than, say, 25 pounds. There may be a limit on how many pets you can allow in that unit. Also, if your property is in the city of Seattle, there are some more complex rules regarding the amount of security deposit you can charge and the amount, or if any, fees you can charge. So you want to look into that very carefully if you're in the city of Seattle. The other big exception to this rule is if you're dealing with a prospective tenant that is disabled. So under the Fair Housing Act, a disabled tenant is allowed to ask for a reasonable accommodation. Now that reasonable accommodation could be a service animal, and a service animal is not considered a pet. So if you do have a prospective tenant and they ask for that reasonable accommodation, you would have to allow that service animal into the property regardless of your pet policy. And something to keep in mind as well is you can't charge an additional security deposit, pet rent, or additional pet deposit. You have to just treat it as any other accommodation. So if you're faced with this issue, there's a couple things you can ask to verify. So if the disability is not readily apparent, you can ask for documentation on that. You can also ask for the need for the accommodation if that's not readily apparent. And what they then would have to provide you is a letter from a doctor or healthcare provider going over those two questions. One thing to know is healthcare provider is pretty broad. So there are a lot of people that qualify as healthcare providers, and it's a little bit hard to tell whether in every case if they are qualified to diagnose, but that's not really up to the landlord. The law just says if they have a letter from a healthcare provider explaining the disability and the need for the accommodation, that meets the requirement. This area of law is really kind of complex, and if you want more information about it, I would recommend that you go to the HUD compliance guidelines. They will give you a real breakdown of how this accommodation works and what you have to do as a landlord to meet that threshold. Also, here at SJA Property Management, I'm happy to talk to you about this. If you have any questions, feel free to reach out to me. We've dealt with these situations many, many times, so we have the expertise and we're willing to help you. All you have to do is reach out. Well, thank you very much. This is another edition of Landlord's Corner. Again, I'm Devin Easterlin from SJA Property Management. Thank you.